Good afternoon, everybody. It's Nick here from Me Learning. Thank you for taking the time out to spend half an hour, 45 minutes with us talking about GDPR and the impact of GDPR on charities and how you can start preparing both your organisation and your staff. I'm Nick Richards from Me Learning, and we're joined today by my colleague Piers Claydon from Claydon Law, who we've been working with in development and in partnership with our training solution, which we'll talk more about a bit later on. We are going to be taking some questions at the end. We are a little tight on time. If we aren't able to answer your question, we will certainly respond to you after the event. So please, if you have any questions, do type them into the little question toolbar over on the side, and we'll address those if we have time at the end of the session. So I'm going to hand over to my colleague Piers shortly, and he's going to talk a little bit about GDPR, the background, why it's a game changer, and in particular relevance, the key implications for charities and non-profit organisations. And then Piers will hand back to myself, and we're going to talk a little bit more about how we may be able to help you in both preparing yourself and preparing your workforce using our online training tool. And I'm going to attempt to do a quick demonstration of that tool so you can get an idea of what it's all about. So I'm going to hand over to Piers. Are you there, Piers?
Yep, Nick, thanks very much.
Thank you, Piers. Over to you.
Thanks very much, Nick. Good afternoon, everyone. Thanks again for joining us on this cold, chilly afternoon. So to warm me up, here's a bit of a primer on GDPR. This is a European piece of legislation which has been knocking around the legislature of Europe for the last 6 years. It finally got published February 2016, due to come into force 25th of May 2018. It is here to stay. Brexit is not going to have any effect on the application of GDPR. Indeed, the UK government has decided to not only enshrine that into UK law through a new Data Protection Act, which is currently going through Parliament, but also extend its ambit to areas which it hadn't hitherto not touched. So it's very much here to stay, and organisations across the land are going to have to get ready for it. Obviously, personal data is a critical asset for many charities, whether that's in terms of supporters or users of services offered by charities, volunteers, and their staff. And it's a game changer because, for a number of reasons actually, the level of fines has received quite a lot of coverage, and indeed charities have been in the firing line for data protection breaches previously. The landscape on that has changed though now, because the ability for the regulators to levy really quite substantial fines has actually increased, potentially up to 4% of annual turnover, or 20 million euros, whichever is the greater. And so obviously a really, really punitive regime there. And you know, the regulator, although previously has taken some heed of the fact that charities who have not complied with data protection legislation have limited resources, we have to accept the fact that ability is there. And it's worth pointing out that the GDPR does not have any, there's no charity exemption of any, which is likely to allow charities to take a slightly more proportionate or approach to compliance. So I'm afraid it's really for everyone to, all organisations, as I say, to get ready for it. So there's the fines. There's an increased ability for data subjects, individuals, to sue organisations who have misused their personal data. And I'll touch on that in a little bit more detail in a minute. So the data protection, the current Data Protection Act is obviously in place until May next year, and the GDPR will continue many of the concepts and principles and indeed definitions that are currently familiar to us from the DPA, but there is a real overlay to the regime with additional elements and significant enhancements, which will mean that organisations are going to have a bit of a mindset change in relation to compliance. Whereas IT and technology may be a key to helping some of that compliance burden, compliance is going to need a cross-organisational approach, whether that's around marketing or fundraising or when dealing with outsourced functions. It needs a joined-up approach. And also, just to note, obviously I'm aware, whilst I'm not a charities lawyer myself, I'm aware that there are additional requirements around fundraising, and there is the fundraising regulators guidance as well, which may in some instances go further than the GDPR. So Nick, if we could move on to the next slide, please. Thanks so much. So this is one of the key new areas under the GDPR, and it is the one which possibly amongst all others is going to cause the most bureaucratic headache for organisations, and that is the one of accountability. And this, in short, is a requirement that requires organisations to not only comply with the law, but also to show how they are complying. And it is across the board. It's not just around fundraising, but it will apply across the charity. And it will require policies and procedures to be put in place to at all times be able to show that you're taking privacy seriously and treating it as a priority. Excuse me. So some of the sort of specific requirements around this are requiring organisations to have in place quite extensive internal records, which will show, if you like, the who, what, where, how, and when of the data processing activities that they conduct, their data processing landscape, if you like, to be able to show, any given time how personal data is flowing through an organisation, if you like, from cradle to grave. Some organisations who handle a lot of sensitive data or do a lot of large-scale monitoring of personal data will have a mandatory requirement to have a data protection officer in place, and that person is will be a sort of privacy guardian, if you like, for individuals' rights under the GDPR. The GDPR goes into a little bit more detail than currently on the sorts of information security measures that organisations will have to have in place, particularly around calling out specifically encryption and so-called pseudonymization, which is different from anonymization, but nevertheless allows a certain degree of risk mitigation from a GDPR point of view. And then finally, the GDPR goes into some length to talk about how it wants to see organisations very much have privacy at the heart of what they do, not just as an afterthought or an add-on, but very much seen at the beginning of any new process, and requiring organisations to excuse me, design their activities so that privacy is at the heart of that, and carry out what are called data protection impact assessments. So before any potentially risky activity, you will be required to think about what are the privacy impacts around what we're going to do, what are the risks, and what sort of mitigation strategies should we be putting in place to reduce those risks. So in terms of sort of practical points to consider, first of all, looking at your existing compliance program and working out where the gaps are between where you are at the moment and where you need to be by May next year. Look at your record keeping and make sure that, your data processing activities are covered in full. Think about the appointment of a data protection officer, whether or not it's mandatory for you. It may still be a good idea to have a person who is going to be in charge of data protection compliance. Looking internally at your policies across the board and how you're going to comply with that, and specifically around training is a great way of training your staff is a great way of showing accountability, because it means that you're taking it seriously And this is where our tie-up with Me Learning is really important, because that particular tool offers a great auditable and verifiable way of showing that you're putting your staff through a really high quality training program. And then also think about, for those of you who may already have some sort of ISO type certifications, that's also a great way of showing that information governance is very much taken seriously in the organisation. So Nick, if you wouldn't mind moving on now. So consent, the picture has changed here as well now, and because where previously consent under the current regime is a relatively relaxed regime, you can get there by implied or pre-tick boxes. Because fundraising is seen as direct marketing by the ICO, within the definition of direct marketing, if you like, it's sort of any material that promotes the aims and objectives of an organisation. It's seen as direct marketing. That would obviously include fundraising. Fundraising, in turn, of course, has depended to a greater or lesser extent on consent previously. Going forward, that consent is going to be difficult to obtain, because you are going to have to show, again with records and being able to demonstrate that the consent has been freely given. It is specific to the processing activity which you're looking to carry out. It is fully informed and it is unambiguous. So silence and pre-tick boxes and inactivity will no longer be enough. And individuals must be able to opt out and revoke their consent as easily as they gave it. And Nick, if you just move on to the next slide, please. Thank you. And because this area is one which deals very much with individuals' rights, this is seen in a more serious light under the GDPR than perhaps other breaches of the GDPR. So this is one that is really important for charities to get right, because this attracts the high level of fines that I mentioned earlier. So in terms of what to do, consents to the extent you already have them, can you use them? You can reuse them, and they will remain valid if they satisfy the GDPR requirements. If they don't, they will need to be resought. Obviously, you need to be able to record and show exactly how and when these consents were given. You should have processes in place which deal with what happens when someone withdraws their consent. How is that treated within the organisation? What processes have you got there to make sure it's properly actioned and in time? And finally, think about where you have previously thought that consent has been a useful tool to lawfully process people's information, people's personal data. It is not the only show in town, and in fact, it may well be that because the consent has now, the threshold has got higher, organisations are going to look at other ways in which they might be able to process personal data. One of these is the so-called legitimate interest ground, which is may allow a charity to say, right, I have a legitimate interest, and the processing I want to do, for example, fundraising, is necessary for that interest, and my fundraising overrides the rights and freedoms of an individual. And where that is the case and it is able to satisfy that test, it may be that consent is not required for direct marketing. And just a little sort of further footnote to that footnote, charities obviously nevertheless will need to comply with their fundraising code of practice, and indeed the rules on the privacy and electronic communications rules about opt-ins and using emails and such like for direct marketing. Okay, thanks Nick. Next one. Thanks. So data processors, where charities outsource any of their functions, for example, where they have large amounts of staff, they may outsource payroll, or where they are using external fundraisers, or doing external email or normal snail mail, mail shots. All of these involve providing personal information outside of the organisation to third parties to conduct something on your behalf. And where that is the case, it is absolutely imperative that charities are able to show that they have done sufficient due diligence on those third parties, on those external organisations, to show to show to anyone who comes to audit them that they have taken care to make sure that the people they're using have the right bona fides in place, have the right technical measures in place to make sure the security is well looked after, and generally they have the right organisational structure to ensure that the information is properly processed. And whilst processors, those external organisations, will themselves be liable for infringements under the GDPR if they don't obey the rules, the primary liability for data processing compliance falls on the charity as the controller, whether or not it's used an external data processor, and it is only ever going to be able to escape that the scrutiny of the regulator, where it's entirely not at fault for the breach, any breach that might have occurred. So, as I say, really important that the paper trail is there to show that you've taken adequate steps to check that these organisations are able to meet GDPR compliance requirements. So the agreements themselves include certain prescribed required provisions, make sure there's a duty of confidentiality on the staff, and no further sort of onward subcontracting without your consent, and also an assistance obligation to help the charity with their own compliance requirements. And having spoken at a charities conference not so long ago, I'm really aware that one of the biggest headaches for charities in this area is around their use of volunteers, and certainly from my analysis, a volunteer obviously isn't an employee and is not an external contractor as such. But nevertheless, I think that the data protection landscape would see a volunteer as a data processor. So it is necessary, I think, for charities to treat volunteers as data processors. And so when I'm talking about data processors on this slide, I do include volunteers within that, especially where they are handling personal data on the charity's behalf. For example, they may be looking at supporters on an Excel spreadsheet in their own time, on their own laptop. Really important that those same volunteers are aware of the charity's obligations under the GDPR. So in terms of where to go from here for charities in terms of compliance, well, clearly, any contract where a third party is engaged to do data processing, and as I say, that includes volunteers, meets the requirements of the GDPR with the extra requirements, the extra provisions that are in there. They should set out clearly and exhaustively the processing that the external organisation is going to carry out on behalf of the charity, and make sure that for your own benefit that the sort of risks and liabilities within that contract are correctly apportioned. Thanks, Nick. Next one, if you don't mind. So this is a new change again for data protection within the UK. The GDPR introduces a breach notification regime for the first time, which makes notification to the regulator mandatory, and that has to be done within 72 hours in the event of a security breach. That's a breach to at least the accidental or unlawful destruction, loss, or disclosure of access to personal data. And so unless an organisation is happy that there is unlikely to be any risk to individuals from that breach, they have to notify the regulator. They also have to notify the affected individuals without delay if there is likely to be a high risk to individuals' rights and freedoms. Now, where it may be possible for the charity to escape that requirement of notifying individuals is where, for example, it has put in place risk mitigation measures such as encryption or remote wiping of remote devices, so wiping devices remotely. In those sorts of scenarios, it's possible that the organisation could not have to notify individuals. The failure to report attracts the lower level of tier. I say lower level, it's obviously still significant, up to 10 million euros or 2% of annual turnover. Plus, obviously, if that reveals any other data protection data protection breach, it would also that could also attract a further fine. Where you're using external organisations or suppliers, there's an obligation on that organisation to inform you as the controller, but they don't have to inform the regulator. It's your job as a controller to inform the regulator. Okay, Nick, thank you. Last slide, I think. Yes, sorry, just finishing up on this point, in terms of practical things to do around here, strongly suggest that you think about putting in place a sort of data breach response plan and make sure everybody knows their roles and responsibilities if and when that ever happens, and so that obviously if it happens, you can respond quickly and within the time necessary. Information security measures are you going to actually be able to tell what's been potentially stolen and who's affected, and think strongly about encryption, certainly for high risk data. Thanks, Nick. So penultimate slide now, just to touch on briefly some of another change which has been introduced by the GDPR. And this has introduced some enhanced rights for individuals. We're quite used, I think, to having so-called subject access rights for individuals to request copies of the personal data that organisations hold on them. Those sorts of rights have been expanded, such as individuals now have a right to be forgotten, if you like, the so-called right to the erasure right, if their organisation, or if their information is no longer needed by an organisation, or they object to the processing, or it's unlawful. And there are exemptions to that, but nevertheless, needs to be thought about how you would comply with such a request. Subject access requests remain. They've changed ever so slightly. I think the ability to charge for a subject access request has now disappeared. Although if it becomes excessive, there may be an ability to levy charges. I have 1 month to respond on that. Where we're involved in automated decision making, and that includes profiling, then individuals have a right to object to that. And also right to appeal if the decision made affects them and they're not happy with it. In other words, have a human being intervene in that decision-making process. And in terms of what to do, strongly recommend sort of carrying out privacy impact assessments and making sure internally that your organisation would be able to cope with any such requests that might come in and be able to action them quickly, and make sure that your sort of customer-facing, individual public-facing functions are able to sort of recognise and then handle and document requests and send them to the right place. And the last slide, Nick, I think, thank you, is just to highlight some of the troubles that charities are obviously having in this area, particularly large, smaller ones. Obviously, with the lack of resources, they're seeing lack of clear guidance as being their biggest challenge, and some of the more common actions that they are taking or planning to take just at the moment, just sort of driving board level discussion, thinking about training, sending staff on external training, and I think Nick may have something to say about that in a moment. And in terms of taking practical steps, a lot of them are looking at privacy policies, auditing current practices, and making sure their supporters are on side with their preferences. And I think that draws to an end my section for the time being. So Nick, over to you.
Thank you very much, Piers. Piers is going to be hanging on the line to answer some questions. We do have some questions coming in. I'm going to rattle through my part pretty quickly because some of these questions I think are quite interesting, and I want to try and make sure we have enough time to cover them all. So in terms of next steps, Piers has hopefully given you some good tips and good ideas and action points for you to follow up on. Part of the challenge, as Piers just highlighted was getting buy-in through the organisation, staff training, sending people out on external training courses. And one of the things you need to have a think about within your organisation is what are the roles, what is the responsibility of the individual within your organisation. We've looked through and had a good think about this, and we've split this down into 4 areas. These areas won't apply to every organisation, but they're common across most. So the board or the trustees of the charity or the board directors of the company, they really need to understand that GDPR is important. They need to understand what it is, and they need to understand what could potentially happen if they don't get it right, both in terms of monetary, but actually probably reputational costs is more damaging in not in being having had a breach and having it splashed over the newspapers. So getting the board on board is very important, because you need their support, you need them to drive it. It's going to take time, and it's going to potentially take money. Excuse me. Then really sitting at the top, if you like, is your data protection officer, if you have one, or the practitioner, basically the person who is responsible to make sure the organisation is compliant. It could be anybody within the organisation, usually somebody relatively senior. In a small charity, it may be the senior director, or in a large organisation, it could be the data protection officer. It's not a constant throughout organisations, but fundamentally, somebody within the organisation has to take responsibility to get this done, and they need to know everything about the GDPR, what it is, why it's there, what needs to be done, and what happens if it's not done. So they really need to understand the whole scenario, the whole GDPR system. Some organisations, and perhaps slightly larger ones, will then that responsibility will be delegated down the line or across the line to other more senior managers, or to somebody who actually has to execute and make compliance happen. Foundation and practitioner could be the same person. In a lot of organisations, somebody will say, right, IT, you need to get this sorted, HR, you need to get this sorted, marketing, you need to get this sorted. So there'll be people that will need to know what they need to do. So they also need to have an understanding of the GDPR and what it's all about, but they also need much more clarity on what's required, what they actually have to do within their role. And then finally, we put the staff. As Piers mentioned, this could be your volunteers with your own internal staff. They also have any staff really who works with personal data and needs to understand what personal data is. They need to understand what the GDPR is, and they need to be clear of what their responsibilities are. And that really is a key part of the GDPR, be able to demonstrate as an organisation that you have provided staff training that's relevant to your staff, that covers the things that they need to do. So the challenge really is as you're doing here today, or you're attending a webinar, the challenge is to find out more about GDPR, and there's a lot out there, as you've no doubt discovered. We keep a track, and we do some Google searches, and we type in GDPR, and as you can see, there's a significant amount of information out on the internet, some of it good, some of it bad, some of it right, some of it wrong, a real mixed bag of information for you to plough through. There are, as Piers said and we're saying, you can attend workshops, you can go to large events, webinars such as the event that we're running today, find legal and statutory guidance on the website and download that, pay for lawyers, pay for consultants and IT companies to come and help you with both the legal side, the technology side. All of those things are available to you, and there's a lot for you to choose from. There's a lot of information out there. And it's difficult to know sometimes where to start, what's relevant, how much of the information what can you trust, how much do you need to spend, and also it takes a lot of time for you to plow through all of that and decide where you need to go next. So what we have done with Piers at Claydon Law is to try and distill everything down to a set of e-learning courses aimed at those 4 areas that we spoke about earlier. So your staff, your board, and the foundation and practitioner. An online resource that provides you all the information that you need to implement GDPR and understand GDPR, and also all the training that you need your staff delivered via an online training portal, so it's audited and available and kept up to date. So we'll be working with Claydon Law over the next 6 to 12 months, updating as legislation changes and keeping the content fresh and relevant. In addition to that, Claydon Law have very kindly offered to provide a 30-minute consultation as part of the purchase of the practitioner package, which is the one that contains all 10 modules. Organisations that purchase that package will have the added benefit of, as well as having the 5 hours training that consists of, a 30-minute consultation from Piers and his team at Claydon Law to help them contextualise that and put it into answer any questions they may have. On our website, that you'll see this form, but just to quickly explain there that the modules are on the far left column, and you can see there are 10 modules covering from introduction and background through individual rights, accountability, breach management and supply chain management. We'll shortly be launching an additional module called GDPR for the marketer. And so this is a course designed specifically for people who are dealing with marketing, so looking at opt-in and opt-out, which will be launching shortly. We can provide information on that as and when. And as you can see, the core, that we've bundled those modules together into training packages. So if you want training for your volunteers or staff, we would recommend those first 3 modules for an hour-and-a-half training. If you're looking for training for your board on the other side, we'd recommend those 3 modules for an hour-and-a-half. And then foundation and practitioner, we bundled those in as well. So I'm just going to quickly jump now to my learning management system. This is a secure cloud-based system. All the modules will be held in here, and when people take their training, they would log into this portal, and it would track everything that they're doing and would chase them to complete their training. And as an organisation, if you've got staff who are using this portal, you would have an administrator license that you could log in, and you can see what training has been done, what training hasn't been done, and chase people accordingly. So I'm not going to go too long. We can give you this access. There's some contact details at the end of this email where we can set you up with access to the site. Fundamentally, you can see all the 4 courses are here. Typically, if I logged in as a user, I'd only see the particular course that I was wanting to take. I'm going to log in. I'm going to have a look at the practitioner course. And I'm just going to run the course and go through a few slides, and then I'm going to move on. We can give you access to these post this event for you to have a look at and have a play with. But as you can see, all the courses are listed out on the side. And if I want to launch a course, I'll take the compliance course and I'll let that run for a few moments.
The GDPR comes into force on the 25th of May 2018, and there is no end of information out there on what organisations need to do to get themselves ready for GDPR compliance. But in this 2-part module, we aim to draw it all together.
So I'll flick through a couple of slides so you get an idea.
On the following topics: awareness, accountability, data mapping, grounds for processing, consent, the Data Protection Officer, DPO, privacy by design and default, and insurance. GDPR compliance is going to need an allocation of resources, both in terms.
So in terms of the learning, you can see there are 17 slides. There's a couple of videos in amongst some of the slides. There are learning points as we go through. There's a short quiz at the end where we ask a number of questions, and if the person successfully gets 80% correct, then they can then progress on to the next module in the course and take that. At the end of the course, if they successfully complete it, they'll get a personalised certificate which can be used as evidence that the course has been taken and passed. So I'm not going to dwell on that. Please speak to the contact at the end of this presentation, and they'll get you access to this, and you can have a look at that at your leisure. I'm going to excuse me, flip back to my presentation. So just really rounding off before I address some of these questions and bring Piers back online again. We did a little bit of research, and sending somebody on a training course, so if you need somebody within your organisation to understand GDPR, You can send them on a classroom course, typically costing £1,000 and £1,800 for a classroom course, anything from 2 to 4 days long. Our practitioner e-learning course is 5 hours long and contains the equivalent training of a 3 to 4 day classroom course. Based on research that small organisations or charities will typically spend £3,000 or £4,000 on legal fees. We think that with the information that's held within the e-learning module plus a backup 30-minute consultation from Claydon Law, there's a very good chance that you could reduce these legal fees, if not eliminate them completely, but certainly reduce the amount of legal consultation and potentially management consultation that you might need to take on board. Obviously, we can save you a lot of time in finding out what's out there on the internet. And finally, we can the nature of our training is that we keep an auditable record of everybody's online training. So part of the compliance and part of it to be able to demonstrate compliance is that you have trained people in the GDPR. So we can kind of tick quite a lot of boxes there for you. I'm just going to go back on bring Piers back online now. Piers, are you there?
Ready? Yep. Ready and waiting.
Good, thanks. So I've had a number of questions. I think some of them you may well already have answered. So I'm gonna ask them anyway because I wouldn't want to assume that they have been answered. But I think, forgive me if some of them have. So quickly, is opt-in required for postal mail, or is it only does it only relate to email, SMS, phone, that type of thing?
The e-privacy regulations only relate to electronic communication, so email. But under GDPR, I mean, consent will, unless you can get it within the legitimate interest grounds, it will need consent. So there's sort of a twin track. There's a twin track. Two pieces of legislation which we need to take heed of. But if you are currently using, if you are currently happy to use Royal Mail for marketing without consent, then at the moment that's fine. But that's fine if you can argue legitimate interest. Not if you are doing it on a consent base. And sorry, the only other footnote is that, again, those rules on direct marketing and fundraising by email, I'm afraid, are due to change next year with the introduction of another e-privacy regulation at European level again, which will be directly impactful on the UK. The current it's still in draft and still going through the process, but the current it currently looks like the so-called soft opt-in rather will continue to apply, but that's not going to help charities because that only works for people who are selling goods and services, not fundraising.
Thanks, Piers. One question here, I think one of our attendees is a church, and the question is, do churches come under corporate bodies, and would this then make them exempt from GDPR legislation?
A church, to the extent that it is a it is a body, and therefore it would be seen to be possibly being a data controller. So I don't think there's any exemption there. No.
Okay, thank you. Question: what is wealth screening, and are any practices still okay, or does it all become too ambiguous under the legitimate interest clause and reasonable expectations? Does this also apply to the prospecting of new partners?
Yeah, it's a really good question, and really, really complicated. Wealth screening has had a lot of scrutiny from the ICO and the fundraising regulator, and it's going to be a legitimate interest type process that organisations are going to have to go through in order to sort of make themselves to sort of see if they have the correct grounds for doing that sort of processing. But it's a really complicated picture, and is not something I'm really willing to sort of go into in depth right now.
Okay. Thanks, Piers. A couple of questions answered in a slightly different way, but I think alluding to the same thing. Talking about holding information and then having to hold information for legal reasons, such as sort of finance or auditing purposes. So if the person hasn't renewed their subscription, or they want to kind of not receive any more information, but they still need to, the organisation still needs to hold information about that donor for legal purposes. Is it possible to put the data either beyond use or put it elsewhere just for auditing purposes? Because some of these have to be kept for 6 years.
Yeah, there's a whole heap of issues there in that question. Let me try and break it down. So, any information, any personal data that an organisation holds on an individual has to be processed on legal grounds. So that the first question is, you know, do you have the legal ground, the legal processing ground for doing whatever you want to do, whether it's you know, a subscription or sending out a mail shot or anything like that. So that's the first point. If an individual wants to opt out, well, if an individual wants to terminate a contract, obviously they're willing to do that. You then, as a data protection obligation, have a requirement not to keep that information for longer than is necessary for the purpose for which it was collected, unless, of course, there are overriding compelling reasons to keep it. And it may be that you are anticipating some sort of legal action with somebody, for example, or in an employment scenario, you might want to keep records for longer, for up to 6 or 7 years, for tax reasons, and again for potential legal reasons, you know, post-employment. So yes, there are those sorts of legitimate reasons for keeping information remain under the GDPR. And the tweak on that, of course, is around if someone exercises their right to be forgotten, their right to erasure, which is basically an overriding. I want you to take all information that you hold on me and absolutely make and put it beyond use, and that applies across the board. So, technically and theoretically, you are required to not only do that within your sort of day-to-day systems, but in the backup as well. And so, yeah, obviously, lots of organisations are grappling with actually in practice how is that ever going to be complied with, and indeed in this day and age, can anything ever be put beyond use? And you know, it's a big question mark over that from a practical point of view. Again, not to be confused with where someone exercises their right to opt out of direct marketing, and that should very much be done through a suppression list system rather than total erasure.
Okay, thanks. I've got a couple of more questions. I know you're tight on time. There should be some yes, no's, hopefully, if we rattle through. Can a member of staff carry out DPIA as we're a small team of 6 people?
Yeah, absolutely. Yeah, of course. Yeah, as long as they have the relevant knowledge to kind of think about the issues and the risk mitigations. Yeah.
Okay. How much data do you have to hold to warrant a data protection officer?
It's the type of processing you're doing rather than it's a qualitative test rather than a quantitative one. So it's whether it's large scale monitoring of personal data or sensitive data.
Okay. Would we need members' consent to send out renewal notices and newsletters that they're entitled to?
Renewal notices, I think, yeah. I mean, that's probably one that you could look at legitimate interest for. But for and again for newsletters, again that could also be a legitimate interest one. So that not necessarily, I think, is the answer to that one.
Okay, interesting one here. Do we need to ask employees permission to hold data like passport copies, driving license, appraisals, supervision records, etc.?
Well, that's a good question. You need with the information you hold on employees, you need to have the correct legal ground for their processing, and by and large, that will be, from an employment point of view, probably covered by legitimate interest or you know, performance of your employment contract with the employee. So in other words, I need your bank account details to pay you. That's not a consent issue. But what you still do need to do, obviously, is all employees have a right to know what information you hold on them and how you process it, where that data sits. You know, do you use external, offshore, outsourced cloud providers to store data, that sort of thing. And that is all. I haven't touched in this presentation on the information notice requirements under the GDPR, but they have increased in terms of the information you have to provide to individuals. And that would be, yeah.
Thanks. There's a very last question here, and then I think we're done. A small charity, 1.5 staff, that's interesting. We don't fundraise with those on our database. We just send information to interested groups or have professional contacts. Do we still need consent?
Sorry, I missed the after the 1.5 staff. I missed the pertinent bit, Nick. Sorry.
Okay, so again, 1.5 staff. We don't fundraise with those on our database. We're mainly funded by London boroughs. We just send information to interested groups or have professional contacts. Do we still need consent?
Okay, so I mean, the point there is that from a GDPR point of view, if it's not personal data and that is information that identifies a living individual or is capable of identifying a living individual, that doesn't fall under GDPR. So if you are sending emails to info@, or if you're sending letters to the managing director of, that's not a GDPR issue.
Thanks, Piers. I think we'll wrap up now. Thank you, Piers, for attending and your insight into the GDPR. Obviously, challenges for everybody. Also, thank you, everybody, for attending. I've put the final slide up, which I'll leave when we sign off, as a point of contact for you to find out any more information. Any questions that we haven't had time to answer, we will address with Piers, and then we'll email you independently of this webinar. And that's it. Thanks ever so much for your time. Thanks, Piers.
Thanks, everyone.
Bye.
Bye-bye.